Good morning, everybody.
Good morning.
Thank you for being here. So, another Friday morning coffee. Today is we're running into the last minute, slight technical difficulty, so we'll be shuffling around just slightly, but we're going to get Stephen Woods started. For those of you who do not know Stephen Woods, he's with Ogletree Deacons. He's a shareholder. Stephen specializes in employment law. He is a graduate of USC School of Law. Stephen actually, for those of you who do know him, you'll know that Stephen and Ogletree Deacons, but Stephen specifically, has been a friend of HTI for a very long time. And we've had not only a working relationship, but he's just a good guy. So he just likes it.
We love Stephen.
Clearly the bride is in the veil.
But we have, one of the things I did want to point out is Ogletree Deacons hosts the Legal Summit once a year, and that is next Tuesday.
We did.
And if you've never attended, it is by far the best legal event of the year. It's incredibly informative. We will be there not only as an organization, but as individuals, because this is something that we do for our own individual development. But it's definitely worth looking into. So if you haven't checked it out, look at what they're going to be covering this year. Try to make it. We'll be sending out, if you give us your email address before you leave, this is good for 1 hour of CE credit. We'll make sure you get the certificate and the certification number for that so that you can get your credit for it. We also, this is a great topic this morning. I'm kind of excited. We've been talking about this for a few months now. Something we see very often on the OS side of things is we go in and we do compliance audits. And one of the easiest places to go to is to take a look at someone's handbook. And the reality is, if you're not sitting down annually and really kind of taking a look at it, because legislation is changing so rapidly that if we're not keeping up with our policies, something very simple can become very complex should we have to apply it and it's no longer fair and reasonable. So with the statutes that change the legalization of same-sex marriage, that has shifted a lot of things. It affects FMLA, it affects the majority of your handbook, really.
Yeah.
And so we had reached out to Steve, and it was funny when we asked the question, so what all does this impact? And his response was, the shorter list would be what it does not impact. And we usually have more of a back and forth on a kind of conversational session, but honestly, this is so important. We're just going to hand it off to Stephen today and let him bring us some knowledge. So, Stephen, thanks for being here.
Thanks, Ron. Thanks, Jim. It's good to see many of you again. Good to see some new faces as well. So if you've been with me before, you're going to hear me say this part that I always say. I am not nearly as funny as Jimmy Kimmel or any other late-night host. So if you would make this a dialogue, not a monologue, that's going to be a whole lot better. Because I'm here for you. We're here to make your lives easier and answer your questions. So let's try to do that. If we don't get your questions answered, then we haven't done a good job this morning. So one thing that Rob forgot to say about me was that before I ascended into the ivory tower where I dispense useless advice to HR and legal departments, I was an HR manager. I was the HR manager at the Greenville News for several years before law school. It was a long time ago. It was from 90 to 93. I left as the FMLA was being implemented. And I was smart. The heck with this, I'm out of here, back to law school. But it was an incredible experience for me, and what it did for me was give me one of the great gifts of my career, which is allow me to see where the practical has to marry the legal. Something I know every single person in this room is dealing with daily. So this is kind of an esoteric topic. It's a socially charged topic as well. We're going to kind of leave some of that behind and just talk about what it means to you from a nuts and bolts perspective to be sure that your handbook's been changed, your benefit plans say what they need to say, that same kind of thing. So if that makes sense to everybody else, we'll buckle up and get started. I should say, is everybody caffeinated? Is everybody hydrated and fed? That's super important. Okay. All right. So here's what we're going to do. We're going to talk through the list of things that are here. And if you want to copy this at any point, just shoot me an email. I'll be glad to send you the presentation. I know Jen and Rob will as well. So if you want an actual copy of it, just let me know. I'm happy to send it to you. And there are a few slides in the actual presentation that I'm not projecting, just to give you a little more in-depth information that I thought might not be as interesting or relevant this morning. So let me know about that. So we're going to talk through why does it matter, and then we're also going to give you just a little bit of history. I'm not huge on the history because really I know what you care about is what's going on today, but I want to do a little bit of that because I think it helps set the table, because you've heard about this topic probably in the news and in other places, but I think it helps to set the table a little bit to let you know, okay, how did we get here? Then I'm going to talk about a little bit about the sort of the practical nuts and bolts of this, which is, what does this mean for us? What does it mean for FMLA? What does it mean for ADA? What does it mean for immigration? What does it mean for Title VII? We are truly right now, this week, at the cutting edge. Earlier this week, March 1st, so that was Tuesday, the EEOC filed its first 2 lawsuits in Maryland and Pennsylvania involving sexual orientation. Very first time they've ever filed litigation on this. They've been doing charges for a while, but they've never filed litigation. So we're going to talk a little bit about that and what that means. It's significant and important for you to know about. We'll talk about that. So if all that sounds good and you're caffeinated and you've got a good scone and you're ready to go, we'll get started. Okay, so why does it matter? I may stand. Can I stand? Okay.
You do whatever you wish.
Okay, here, just so I got to turn around. So I put some statistics up here. So again, I said this is a very socially charged subject. Some people feel extremely strongly about it. Some people don't feel as strongly about it, kind of in the middle. But whether you feel one way or the other, the stats are what they are. You look at the stats that are here, there are 9 million LGBT, lesbian, gay, bisexual, or transgender adults in the U.S. 700,000 of those are transgender. If you look at the 2010 U.S. Census data, 594,000 same-sex couple households in the U.S., 25% reported they were spouses. Now, in 2010, there were only a couple of states where same-sex couples could actually be true legal spouses, but they considered themselves to be spouses, so that's kind of a telling thing. We're 6 years later, and we're going to talk about the case law that got us to where we are. Now, if you're married, either under justice of the peace in a church, or you went to some kind of courthouse to do that, or if you, in South Carolina, if you hold yourself out as married under common law, you are married and you are a legal spouse, same sex or traditional.
What number would you guess that 594,000 6 years ago? I can't imagine that it's that small of 9 million.
I think that's right.
I would think it's at least a couple of million.
So some wedding planners would probably agree with that, and some hotels and other venues. I think it's gone up considerably since then, and I think that the next census, which is, I don't know when's the next census? 2020. I think the census in 2020 will probably bear out an even more accurate number. This was a pretty large jump from the prior census, and it was sort of, I think, surprising to a lot of people in the gay and lesbian community, people in the traditional non-gay and lesbian community, to be able to say, oh God, that's a large number. I do think it's going to jump even further. Great point. Thanks for the information about the census. Okay, and then I think that we've had in our society, and again, I'm not going to talk too much about this, although I certainly am happy to talk after about any of this. I think we've also had in our society, no matter how you feel about it, socially, religiously, morally, otherwise, we've had what we kind of call the Will and Grace effect, where Will and Grace, the television show from NBC in the 90s and early 2000s, has put this topic in a more mainstream light. And so people have always known people who are lesbian, gay, bisexual, or transgender. Now more people are out, and as a result, more people say they know somebody. And just like anything else in this world, when you know somebody who is whatever, black, Asian, disabled, older, whatever, pregnant, once you know somebody who is that, it makes a difference. It makes it more real to you, and it's not some concept. It's a more tangible thing. Okay, I promised I wasn't going to get too social on you, and I'm not. Okay, so here's a cover. So there's Ernie and Bert. You know, my son is 3. He loves Sesame Street. Today he loves Scooby-Doo and Paw Patrol as well, but he also loves Scooby-Doo. And, you know, there's all these jokes about Ernie and Bert. You know, they've been roommates for now 40 years, and what's going on there. So Ernie and Bert are watching the Supreme Court here as we talk about the demise of DOMA. So DOMA, the Defense of Marriage Act, actually came in under, ironically, President Clinton, and in that era it was sort of a compromise that was put in place to try to appease some political winds. DOMA said marriage is one man and one woman. Well, in 2013, that was struck down. Let me tell you a little bit about these two who are here. So Windsor and her partner, wife, were together for almost 40 years. You can sort of see the passage of time. You start with sort of this era and you get to this era. And in the end, Windsor's partner developed a debilitating illness and died. And after she died, the taxation rate that was imposed on Windsor was, in the non-spouse context, it was almost 50%. So for those of you who in the room who are married, me included, when you pass assets back and forth at death or during life, back and forth to your spouse, there's no taxation. Different for your children, different for others that you care about, different from parent to child, but spouses have this unlimited ability to pass this around. This was the perfect couple for this case for the gay and lesbian community. They had been active members in their community, and this was not about sex. It was not about special rights. It was about not letting the government take more tax dollars than they thought they should have. And so when Windsor went up, the argument was that Windsor had paid 50% of the estate for her spouse, and that had they been a traditional couple, husband and wife, as opposed to wife and wife, that wouldn't have happened. And it was hundreds of thousands of dollars. Now, the lawyers who took on this case did so for free, so there wasn't a lot of lawyer bills associated with that because it was such a landmark case. But for Windsor, she paid in taxes hundreds of thousands of dollars that she wouldn't have had to do. So when this went up, the Supreme Court eventually said that Section 3 of DOMA, the Defense of Marriage Act, was unconstitutional because it violated the Equal Protection Clause. So this was a huge decision, and it was based on a number of factors coming together. It appealed to some extent to some conservative members of the court because they don't love taxes, and it appealed to the social liberal members of the court because they think that gay people ought to be able to have equal protection. So it was kind of the perfect storm. And that in 2013 is what kind of started the movement that then culminated in a few years later with the case that we're going to talk about in a second. So also in 2013, the Supreme Court is famous for sort of issuing decisions, landmark decisions in early June. Not always, but they have traditionally done some of their biggest ones then because they take a big recess after that. they do it and they're like, we're gone. We're out of here. So they did two at the same time, June 26, 2013. They did Windsor, which said DOMA is gone because it violates equal protection, and they did this one, which was about Prop 8. And if you've traveled in California or have friends or relatives in California, Prop 8 was a huge thing. Prop 8 was amending the California Constitution to recognize marriage between a man and a woman. South Carolina had has on its books such a constitutional amendment currently. It says marriage is between a man and a woman. So do many other states, especially in the Southeast. There was this wave of state constitutional amendments that were passed in the mid-2000s to try to stem the tide of what some people thought was, huge social liberalism. And Prop 8 was no different. The folks who were in favor of that, the proponents of Prop 8, had tried to undo some things that had happened in California, and as a result, there was a legal battle, as there always is, and the proponents of Prop 8, which were people that would have done away with gay marriage, were found in a very, very technical ruling to have had no standing. Now that's a bunch of lawyer stuff. They didn't meet the test to be able to have standing to bring the case, and as a result, it went away. And when the case went away, Prop 8 did as well. And when that happened, gay marriage resumed in California. So that's 2013. Two kind of bam, 1-2 punches in 2013. Now in 2015, this is really the case that matters to you all. But I wanted to give you that setup to say there was some precedent and there was some momentum growing beginning in 2013. So we get to 2015, again, here we are, June of 2015. They do the same thing again. This was about marriage. And there were several couples that came together. The lead couple, their names were Obergefell. The Obergefell case is about marriage. And at the end of the day, the constitutional issues that are listed here, there were two questions before the court: equal protection and recognition of marriage performed one place and where the couples live in another place. So there is place of celebration. There was a rule called place of celebration, which meant do we honor the marriage based on where you celebrated the marriage and had the marriage, or do we honor place of residence? I'll give you a personal story. My husband, Kevin, and I have been together, let me count up, I got to get this right, 18 years this year. And before our son was born in 2013, it was important to us for a lot of reasons, for spiritual reasons, religious reasons, moral reasons, cultural reasons, parent reasons. We wanted to be married before our son arrived in the world. And so in December of 2012, we flew to New York, and I think we were already good parents because we took advantage of none of the fun of New York. We were on a mission. We got to New York, we got married, we did that at the same courthouse that you see on the steps for Law and Order. A lot of those scenes are shot there. It was really pretty cool. We got married on a Thursday, and we had a great lunch, got a little tipsy, had a great dinner that night with some of my law partners in New York, and we turned right back around and flew home. So we got back home to South Carolina, and we were not married in South Carolina. And that year, we were able to file after DOMA. After DOMA got struck down, but before Obergefell got struck down, our tax return was kind of interesting. So in South Carolina, so federally, we were married because New York recognized same-sex marriage, and so we were married there. That's place of celebration. So between Windsor and Obergefell, this was how we filed our taxes. We filed a federal tax return in which we were married. And for those of you who are married, you know for your state return, you attach a virtual copy of your federal return. Well, because South Carolina did not recognize same-sex marriage, we had to create a fake federal return and attach the federal return to our South Carolina return to show that we were not married. So we were married under the federal, and then when we filed the state, you have to attach the federal, and since South Carolina didn't recognize it, we had to do that. And since my smart, really bright, better than any accountant I found mother does my taxes, she was scratching her head going, how do I do this? So just kind of a tangible example of that. So we were in this gap between 2010 and 2013 and 2015. And so after Obergefell, this case said that if Kevin and I were legally married in another state, that had to be recognized in South Carolina. And the other thing it did was it said that anybody who wants to marry same-sex or opposite sex has the ability to marry because of the Equal Protection Clause. So it did two things. It had the effect of legitimizing marriages that were done one place, recognizing those in the state of residence, and they also said everybody gets to get married. Now, tune into any debate, typically Republican or Democrat, and they'll talk about this, repealing it, changing it, activist judges, whatever you want to say. But that's a political issue during this campaign cycle. So that is going to be something that happens, and as we're going to talk about in a second, the executive branch has the ability to do a lot of things. It will be harder. Let's say that I'm not making this political. I'm just parroting what the candidate has said. If Marco Rubio gets elected, he wants to do away with same-sex marriage. It will be harder for him to do away with same-sex marriage than it was for Barack Obama to allow same-sex marriage because of this decision. It's harder to undo a Supreme Court decision than it is to do something in the absence of a Supreme Court decision. So President Obama extended same-sex benefits to federal contractor employees, to federal employees prior to Obergefell, and as a result of that, he wasn't fighting a Supreme Court decision. Marco Rubio, Ted Cruz, Donald Trump less so, but Cruz and Rubio have both said they are not in favor of same-sex marriage and that it will be their mission to do it. The only way to do it will be legislatively. It will be difficult for them to do it by executive order because there is an existing law. So you can do an executive order in the absence of contrary case law. You cannot undo existing case law. Questions about that? Did I do okay not making that political? Okay. All right. So that's background. So let's talk about what it means to you. Title VII. Title VII makes discrimination in employment based on gender, race, religion, national origin unlawful. For many, many years, the EEOC has been gradually moving from gender, meaning just being a man, just being a woman, to interpreting gender to include sexual orientation. Honestly, while I might have a social view on this, as you might imagine, I also think from a pure legal perspective that the EEOC has been overreaching. But I'm going to be in the clear minority, as you're about to see. The courts are embracing this, or I think going to embrace this, but the statute says gender. It doesn't say sexual orientation, and people can be a man and be heterosexual. They can be a man and they can be homosexual. That, to me, is not gender in the way that Congress originally intended it. So that's coming from me saying that. But the EEOC has taken a different opinion. They've said that if it weren't for the, follow this legally, if it weren't for the gender of the lesbian woman, she wouldn't have had sexual orientation discrimination, and as a result, what happened to her, using an example, is unlawful. Does that make sense? So they use gender to get to sexual orientation by saying that you wouldn't be gay, lesbian, bisexual, whatever, if you were not that gender. It's creative. I think it's overreaching, but that's the trend, and that's what I want to share with you as we talk about this. So there are a lot of things that the EEOC has worked on to try to do this, and then there are some state and local protections. South Carolina, shockingly, does not have any local or municipal ordinances except in Columbia. Columbia does have some sexual orientation protection in the city of Columbia, and that's really about it, and that's for public employment and housing and some private housing as well. That is the only state or local statute that we have in South Carolina. There are a variety of other places. How many of you have responsibilities outside of South Carolina? Yeah. So if you're outside of South Carolina, there are some states that do have it. Atlanta, Fulton County has it, for example. That's really kind of the closest one. Some in the Research Triangle Park area, RTP area, have some protections, which are not necessary now that the law has begun to change from a federal perspective. So the EEOC is everywhere. That's federal. And so I throw this up just to tell you that there's a little bit of a patchwork here. If you have outside of South Carolina responsibility, you'll want to think about what local and federal statutes might be there. Okay, so this is where the EEOC has gone, and this is kind of a brief overview of what I said. They take gender and they use gender to get to sexual orientation. Now, we talked about this. This, from my world, is historic. So on March 1st, the commission felt strongly enough, after having probably for 5+ years, you all know how this works. You know, when somebody files a charge of discrimination, they file a charge with the EEOC. That's the administrative phase. The EEOC investigates, they do all that they're going to do, and once they're done, they either find cause or they find no cause. If they find no cause, the person gets a right to sue letter, and they can then file their own private cause of action with one of these fine plaintiffs' lawyers that we have in upstate South Carolina. They can file a private cause of action. If the EEOC finds cause, the EEOC can either take up that case and litigate it on behalf of the individual, or they can still issue a right to sue, and that person can go out and find their own lawyer. Well, all through this administrative stage, for 5+ years, the commission has been bringing charges based on sexual orientation regularly. We've seen it all over the place, including in Greenville. This is the first time that they've gone all the way through that administrative phase, found cause, and said, we're taking this case. And there are two cases. One is a gay man, one is a lesbian woman. The facts, of course, are, if they are correct as alleged, are terrible. You know, terrible epithets, terrible comments, terrible kidding, you know, terrible Facebook posts, all kinds of stuff. And the commission is not stupid. They choose as their first cases ones that have facts that will be compelling to a jury, to a judge, to the public. They choose the worst cases they can find in order to bring those forward. And so these cases were filed Monday with a pretty large amount of fanfare. And so it's going to be interesting to see how that progresses and what happens with this. First time that's been done in private court. Questions about that? You can take that back for any parties you're going to this weekend. You can say, guess what happened this week? I'm guessing this will not make, what is it, Last Night This Week? What's that show on HBO? Yeah, I don't think this will make it. Maybe. But it was big in our world. And I think it's a seminal watershed moment. So the EEOC has already been busy even before March 1st. Last year they brought this case. This was in a federal type of appeal court. Doesn't really bind private employers, which I think most of you are. This was a public employment case, but it gives you a hint as to where they were going. There's a court for just federal employees, and that got to this level already. So they were warming up. They did all the administrative stuff. They've been doing that for 5+ years. Now they've warmed up by bringing this case, and now they're going to bring these. Okay. So this is not new. Many of you have been around for long enough to remember how this started to evolve and how non-sexual same-sex abuse and harassment came to be. When we have Oncology here, that was filed back in 1998. Remember that? That was huge. It was a watershed moment when they said that these this guy who worked on an oil rig was incredibly harassed. He was straight. The people who harassed him were straight. They were all men. They did egregious things. They said egregious things to him. They, mocked him sexually, but not in a, there was no desire or romance with it. It was all, as I like to call it, boys on steroids, teenage boys on steroids in the locker room. I mean, it was lots of dirty comments and that kind of thing, and it was pretty bad. And that case went all the way up to the U.S. Supreme Court, and they said, yeah, that violates Title VII. And so this is not new. It's just kind of a continuation. And we've seen that over the years as things have happened. Questions about that? Okay. All right. So many of you may already prohibit sexual orientation discrimination. My firm enacted sexual orientation discrimination in 1998. We were, I think, ahead of the curve from a lot of companies because we had some lawyers who were out, and our leadership felt like it was important to do, and I think that was the right thing to do. It helped us with recruitment. It helped us with culture. I think there were a lot of things that it helped with, and now that we're the third largest labor and employment firm in the country, it would be expected that we would have that kind of thing, because that would never fly if we didn't have something like that, given that we're in California and Boston and New York and lots of other places where that's important. But you see the stats here, going back to what we were talking about with the population, I think that's probably just going to continue. How many of you currently prohibit sexual orientation in your policies?
Prohibit harassment.
Yeah. So if I were editing your handbook today, still today, without a federal statute like ENDA, the Employment Non-Discrimination Act, I would still tell you, if you wrote sexual orientation in your non-discrimination policy, I would say to you, this is optional in South Carolina, because we don't have a federal statute. We have the EEOC heading in this direction, but we don't have definitive federal statute. Now, many of our clients will say, thank you so much, lawyer boy, but that's culturally important to us, and I want to put it in. What's the downside? My answer to that is there's no downside as long as you have a good disclaimer in South Carolina. If you don't have a good disclaimer in South Carolina and you put sexual orientation in, you risk a breach of implied contract claim by someone saying, even though the law, Title VII, through the EEOC evolving, notwithstanding, if they said, you fired me because I'm gay, we would say, no, we didn't, because we know the EEOC takes the position that that's protected. But they could also bring a claim saying, even if the law doesn't allow this, the handbook created a contract. And so as long as you've got a good disclaimer, there's no downside to doing it.
And the disclaimer is the, I just left my mind, the
underlined, the at-will
statement.
disclaimer, yeah. That was passed in 2004. That was the year I did 45 handbooks. Yay. That was a lot of fun. Truly. 2002, it might have been 2002. It's the one that, don't you love it when our General Assembly is hard at work at this instead of roads? Sorry, that was political. They say things like it has to be underlined, all capitals, on the first page, and signed. That's what I mean by a disclaimer.
It's not specific to sexual orientation.
It's not.
It's the overall.
It's the overall handbook disclaimer. The only downside, again, to putting sexual orientation in a handbook is if you don't have a disclaimer. And I think the more clear the EEOC's position, I think the less that's even an issue. But still today, without a statute, I would flag it, because we get in handbooks a lot of times that say, we protect based on age, gender, race, etc., and they say sexual orientation, and I always flag it to say optional in South Carolina. That will probably not be the case a terrible amount longer, but for now, I still flag it.
But as a private company, can't you make any policy that you want as long as it's not illegal?
Absolutely. My concern would be that, especially 5 years ago, before the EEOC was pretty clear that they were going to prosecute sexual orientation, my point in flagging that would be that if you did a handbook 5 years ago, the EEOC was not as clear as they had been, and someone came in and said, let's say they were a terrible employee. I know you've never had any like that, right? Nobody's ever had a problem employee that you wanted to get rid of. Never, right? That pays the mortgage on my house, by the way. If they came in and you fired them and they said, well, you fired me because I'm gay. 5 years ago, before the EEOC was quite as active as it's been, we would have said sexual orientation is not a protected characteristic under Title VII, and we would have said, and you don't have any basis to do that. What they would have said in return was, it is protected by Title VII, that's one issue, and they would have said, this handbook where you named it as a protected characteristic, if you didn't do a good handbook at-will disclaimer, that's your contract that you're not going to discriminate against me, so I'm bringing a breach of contract claim against you. Yeah, I think it's really, the importance of that is diminishing. We're kind of in that middle ground between where it used to be important and where it is today.
You do have employees that are around the nation in other states. I mean, would you go ahead and suggest putting that in your handbooks?
I would. If you're in multi-states, then you already have lots of fun with handbooks, drug testing, unemployment claims, the kinds of things that are state-by-state basis. And so one of the things you have to think about with that handbook is, am I going to do one handbook and addenda, or am I going to do the lowest common denominator? In California, you have to pay vacation upon termination. In South Carolina, you don't. So do we do something for California with something different for South Carolina, or do we do lowest common denominator and pay out vacation? So if you are, the answer to that, I think, depends on whether you're doing a lowest common denominator, one size fits all, or you're going to do kind of a just what I need to do in California, just what I need to do in South Carolina, and that's cultural as much as legal, because you will be likely telling people in South Carolina that you're doing it over here, but you're not going to do it here in South Carolina because we don't have to. And to me, that's okay, but that's a cultural decision. Easiest thing to do is put it in across the board. Yes, sir.
Stephen, where are we with ENDA? I mean, that's been kind of batted around for several years now, and that any time now it's going to happen, and so far it has not.
You can imagine I've heard that for a while. ENDA is, it has been reintroduced. It is pending, but I think that there are such larger issues before the Congress right now that one probably is not going to gain as much attention as you might think. And if you read political pundits, they say that the parties are doing this instead of this, which is a shame, because we used to get a lot done when they did this, because that's the spirit of compromise, which also pays my mortgage. And they're doing this, and as they do this, I think that makes statutory legislative fixes much less likely. Great question. All right, what else? All right, so Title VII, let's talk about FMLA. So post-Windsor, and there are a lot of words up here, sorry. I completely violated the PowerPoint rule by putting more than 10 words on a slide. But come on, I'm a lawyer, and it's all about words. So, I don't get paid by the word anymore. So yeah, I got to put these words up here. This got changed after Windsor. This is the FMLA statute definition of spouse. And you see in red I put in, includes an individual in a same-sex or common law marriage, and then it talks about place of celebration, was entered into in a state that recognizes, or if entered into outside of the state, is valid in the place entered into. So that is the new definition. So between Windsor in 2013 and Obergefell in 2015, the DOL took the step to make same-sex spouses covered under the FMLA. So in South Carolina, when Jen and Rob and I were talking about this presentation, they said, you know what, maybe we ought to do a little refresher on common law marriage. So that's here. Here's the rule in South Carolina. In South Carolina, common law marriage has a couple of components. And again, I'll be glad to send you this PowerPoint. Jen and Rob will be glad to send it to you, whatever you want on this. Here's the South Carolina definition of common law marriage, which again, if you are common law married in South Carolina, same sex or opposite sex, you are then married, and you are married for purposes of FMLA. And so you are granted FMLA leave as a result of being common law married. Now, here's an important note. There's no such thing as common law divorce. So if you are common law married, one of two things happens. Either both parties sort of walk away and take their own stuff and deal with children and other issues like big boys and girls, or they don't. And if they don't, then common law married couples wind up in divorce court. So people who some people who are common law married, it's a very intentional choice. Some people who are common law married, it ain't. It's kind of I think I can put up with him one more day. And we've been hanging out now for 20 years, so maybe we'll call each other married. Once they're common law married, there is no legal way to separate except to do a divorce. Now, because common law marriage does not have a marriage certificate and they're not on the books as being married, there is a walkaway. You can kind of walk away, but they both have to be big boys and girls. So if one's a big boy and one's not a big girl, or one's a big girl and not a big boy, then one can still file a divorce and they're off to the races in family court.
What would you recommend
For documentation?
for documentation to take someone off your benefits?
Sure. So coming on, I think that you ought to have them, if you're putting somebody on who tells you they're common law married, I would make them sign an affidavit attesting to all of these elements. I think that is the right thing to do, whether they're opposite sex, same sex, etc. I think that's a smart thing to do. If they want to take someone off, so this is where my practical fights my legal, you can't let, in some retirement plan cases, as you all know, you can't let someone take their spouse off if they are traditionally married, non-common law married, and I don't think you can let common law spouses either once they have declared themselves to be common law. Now, that's one downside to doing an affidavit. If you didn't do an affidavit and they came in and they put their longtime partner, boyfriend, girlfriend on, and then they came back in 6 months or 6 days later and said, I want that person off, and they had not done the affidavit, I think you kind of could do it because they haven't told you that's their common law spouse. So I think there's some pros to doing an affidavit, which is to not let, forgive me, this month's boyfriend or this month's girlfriend on the benefits or on the plan, that the affidavit helps with that because you have to be intentional. We ought to have a little contest to see how many affidavits people have in their files after the next 10 years. It keeps people from being able to throw people onto their benefits, but it does make it harder for you to take somebody off as a beneficiary for a retirement plan because once they're a spouse, they're spouse until a court tells you otherwise. That will continue to evolve.
So they can't come back and file an affidavit, I am no longer common law married, because that has to be a legal document at that point.
There is really only one way to dissolve a common law marriage, and that's through divorce court. Absent retirement plan and health plan kinds of issues, which really do require a court order and a divorce decree or a separation order or something of that nature, they can walk away from a common law marriage and it works out just fine. But for you, for anything where you couldn't take a spouse off, you can't take a common law spouse off. Yes, ma'am.
Am I correct in saying that common law marriage is defined by state lengthwise? So how would that transfer if, a couple were to be common law married in this state and then were to relocate?
That's a great question. So common law is state by state. The test that I put up here is for South Carolina. And so the Georgia definition may be different. The North Carolina definition may be different. And so if you had someone who was working for you and they resided in South Carolina, this would be the definition. If you had somebody who was common law married in South Carolina and then moved over to Georgia, unlike traditional marriage, official marriage, I'll say, I shouldn't call it traditional marriage, because that's opposite sex. Sort of common marriage as opposed to common law marriage, that has to start over. And so when you get to Georgia, it's not that the time they were together in South Carolina wouldn't count, but it does have to be assessed based on Georgia law. That's one of those hard ones. Drug testing, unemployment, EEO, this kind of common law thing, that is very state by state. Great question. So I put the South Carolina definitions up just so you could see that. Legally free to marry, that means you're not already married to somebody else unless you're into, multiple wives and husbands. That's a different presentation. You have to be at least age 16. That is higher than it used to be in South Carolina, by the way, scarily enough. Product of parents who married at 18 and 20. You have to cohabitate, so you can't be living apart. You have to, it's lawyer, come on, sorry. You have to exhibit a present intent to be married. Here's a funny one. You cannot be engaged, because by definition, if you're engaged, you're not married. So you can't say I'm engaged and be common law. So if you say I'm engaged, not common law. If you're common law, can't be engaged. You must hold yourselves out to the public as married. Here are a couple of things that would constitute that. You present yourselves as married. You introduce him or her as my spouse or some other similar term. You name each other on insurance policies before you are considered common law. You file joint income tax returns. Those are some ways that you demonstrate that. So that's the definition of common law in South Carolina. Now, back to same sex, in loco parentis, which is commonly applied with a grandmother or grandfather raising a child, that is not impacted by any of this. But in the same-sex world, here's how that would look. I am not the actual parent of a child, but I meet and fall in love with a new partner, and as a result of that, I am standing in loco parentis to my new partner's child, and so in loco parentis gives me FMLA leave rights as in loco parentis. Make sense? Yes, ma'am.
Is it in our best interest as HR professionals to get documentation if they hold themselves out to be married, or is it just as simple as, do you hold yourself as married? Are you?
I think it is, and I think it kind of goes back to what we were talking about before. It's better to keep people from being able to put this month's boyfriend on the books as being a beneficiary or being a health insured individual. But where it's hard is for retirement plans that you can't take off. The eye daughter in me, shocking to all of you that I'm an eye daughter, right? The eye daughter, and I'm sure I'm speaking to kindred spirits in the room, the eye daughter in me wants an affidavit. Yeah, I want you to tell me. But then getting them off when they split, it's kind of a mixed bag.
Do we have to tell them that? I mean, should we advise them on that, or should we leave that out?
As you know, you should never give legal advice, but you can be the smartest woman in the room. It's okay for you to say to that person when they come in, now before you do this, I just want to make sure you understand what this means. It means that once you're common law, then they're able to be covered by health insurance and named as beneficiaries, and they get, life insurance, whatever that means in your organization. But the downside is that once you do this, I can't let you take them off as a beneficiary for this plan, this plan, and this plan.
Is there not kind of a reverse discrimination risk of we don't require opposite sex partners to give us a copy of their marriage certificate?
Right.
But we would require the affidavit of same sex.
Great question. I would require an affidavit from everybody. Same sex, opposite sex, who are not on common law. I would require an affidavit from a same-sex common law couple or an opposite-sex common law couple. Same way. I don't know what we thought we were going to do with them. I think we got 10 copies of our marriage license. That's just, I'm just a lawyer. So while I was there, they were like, how many copies do you want? I was like, 20. And they were like, 20? I think we used 2. Yeah. Okay. So ADA implications. Specifically excluded from the ADA, and remember that the ADA was passed originally in 1990. So see, I was an HR manager during those days. This was the early ADA days before we knew anything, when we thought it was all about job descriptions. Got to get the job descriptions right. Got to get the. That's what we did from 1990 to 1993 on a dot matrix printer. Yeah, it was cool. So in those days, 1990. Excluded and still excluded under the protections of the ADA are homosexuality, bisexuality, transsexualism, transvestism, and gender identity orders not arising from physical impairments. So that's not covered by the ADA at all. So today, same-sex marriage, same-sex relationships have no true ADA linkage. There was no expansion of any of that under the ADA. There was no associational increase as a result of the decisions, none at all. Now, there have been lawsuits alleging that the exclusions for some of these things here violate equal protection, and therefore the law is unlawful. Those have not made their way very far, but they're underway. Benefits. We talked about this. Pre-Obergefell, 66% of Fortune 500 employers already provided domestic partner health insurance. So now that same-sex couples can marry, do you do away with that? What have you all done? Let me ask it this way. Pre-Obergefell, how many of you were providing partner benefits for both same-sex and opposite-sex couples if you came in and said, this is my domestic partner? Anybody? Okay, we were doing that at Ogletree. And then after Obergefell, the interesting quandary is, do I do away with that? Do I say, you are not saying your common law, so you're not meeting all those elements that I laid out for you before, but you consider this person your partner, because there is kind of an in-between. Maybe you consider them your partner, but you haven't, so you're probably satisfying this one, you're holding yourselves out to the public, but maybe you don't intend to be married, you don't have a present intent. Maybe you tell everybody, like my wonderful secretary of 19 years did. She dated her boyfriend for 15 years, and they finally got married they're in their 60s. They got married 5 years ago. They're doing fine. 20 years together. But they never told people they were married. But if she wanted to, she could have put him on her health insurance because he was her domestic partner, but he was not her common law spouse. So there is this kind of in-between status where people are. And so the question that I would ask you to just think about is, what does that do to you? Do you say, okay, now that anybody, same sex or opposite sex, can get married, we're not going to give non-common law, non-full marriage, we're not going to give health insurance benefits to anybody who does not get married, same sex or opposite sex, or is common law married. You can do that. And that would do away with domestic partner benefits whatsoever. And the thought would be that if this opposite sex couple, because domestic partner benefits started for gay people. I mean, that's how it started, and then it began to be expanded to traditional couples that didn't want to get married. So the question for you is, if you want to do away with that, you could do that if you wanted to. Now, culturally, do you want to do that? Maybe. We haven't seen a huge trend yet in this, but you see the argument. If you want my benefits, put your money where your mouth is, get married. You couldn't get married before, same-sex couple. Now you can. Get on it. Or don't get health insurance. That sounds harsh, right? I don't mean it to sound harsh, but that's kind of the thought. Okay, immigration. No changes to that. The USCIS guidance was issued post-Windsor, and they treat same-sex spouses as spouses, and have been doing that since 2013. Affirmative action. How many of you are subject to affirmative action requirements? Anybody? Okay, so not a ton of immediate action in the AAP, OFCCP world, because it's about marriage, which is not traditionally a category that you track, but we're still waiting for the dust to settle. So as that settles, we'll probably see something. Now, I want to quickly just run through President Obama, what he did. We were talking before about executive orders, and I said before to you all, it's a lot easier for the president, whoever that is, to do things in the absence of a law to the contrary. So President Obama, once DOMA was gone in 2013, which said marriage was between a man and a woman, that allowed President Obama to sign this into law between Windsor and Obergefell. So before Obergefell, before marriage was lawful for same-sex couples all over the country, President Obama took some action. And here's what he said. It was on July 21st, and he, in the incredibly eloquent way that he always speaks, talked about why he was doing it, and had some great turns of the phrase, like all presidents do, to be able to say why he was doing what he was doing. So he did this between Windsor, which was not a marriage decision, it was a tax decision, and Obergefell, which was a marriage decision. And what it did was it added sexual orientation discrimination in the civilian federal workplace as a gender identity as a protected class, and it amended 11246, which many of you heard over the years, and created a new protection for federal workers and for federal contractors based on sexual orientation. 26 million employees are 22% of the total civilian workforce. It was big with a pen. It's harder to undo something that has been found to be law than it is to do something. So President Obama couldn't do this while DOMA was still around, because DOMA said marriage is between a man and a woman. He could not do this executive order when there was a law on the books saying otherwise, which is why I say, contrary to what candidates Rubio et al. Say, they'll have to have a legislative fix to be able to do some of this, or a Supreme Court fix. Okay. Come on. Questions? You all have asked good ones. It's a free lawyer at the front of the room. Come on. And it's a Friday. And you got caffeine. Come on. I will be glad to stick around. Thank you for making this a dialogue and not a monologue. I hope you enjoyed it as much as I did. Thanks.
Thanks for joining us. We always love when Stephen and his team members can join us and just add value to what we do on a daily basis. We do have a few upcoming events. Each of you should have this in front of you. Our next Friday morning coffee is exciting. We have Caroline Caldwell. She is actually she owns a company here locally that helps employees or helps individuals who are trying to re-enter the workforce after a conviction. And she's also the TEDx curator for Greenville, so she is extremely exciting. So we're happy to have her next month. There are a couple of other things. Rob and I are co-facilitating a culture series that starts next week. It's really going to be awesome. I mean, we've created this from scratch. It's the first session is on March the 10th, but basically we're going to try to assist leaders and HR professionals in creating an engaged workforce. And we just have some great stuff there. As far as the last item that's mentioned on your sheet, we have a leadership series and employment law series that we do a few times a year, and so we'll have that in April. So thanks for joining us. We're going to make our promise in the 9:30 hard stop, so we'll hang around for questions if you have any.